All right, we've gone through how to exit the comp system and the 4 steps to becoming a responsible non-subscriber and the difference between a policy and an ERISA. What we're going to talk about a little bit today is mediation binding arbitration. I was not aware of the fact that when I got into the insurance industry that I was going to have to become conversant in federal arbitration law, but as these policies have changed over the years, they have gotten better. The original policies that came out were just policies. There was no ERISA. And then they started adding a very minor, short version of an ERISA, and that was an improvement. And then they got to where they really expanded the ERISA and put some clout in it. One thing about ERISA and clout, you can literally write into your ERISA plan that the employee is required to turn in his claim or report his injury prior to the end of his shift. If he clocks out, he can't turn it in. So that's the structure and the power that is inside an ERISA. But even though we have a policy and an ERISA, you're still a non-subscriber. Remember, we went through the DWC-5 and the notice to the employees and the posters and all that stuff. You are a non-subscriber. And don't forget that the employee regains his right to sue you for work-related injury. Now, his basically only cause of action is negligence, but it's there, and it can be a problem. Now, on these policies we've talked about, they do have the duty to defend, and because of the ERISA limit being different from the policy limit, you have all that money left to settle the case with, and you don't have to worry about court costs because they're all covered, and there's no limit on those court costs. But here in the past few years, they've even added another little twist, which most people think is a great idea. Some employers don't like it. It's called mediation and binding arbitration. According to the Federal Arbitration Act, because of the litigious society and the backed up court system and all this other stuff, the length of time it takes to resolve a dispute, they wrote the Federal Arbitration Act, which says if the employer decides that disputes will be settled through mediation arbitration instead of in a court of law, then that's the way it is. Now, what's amazing is it's really the Federal Arbitration Act of 1934. I don't know if you could even get that thing written today, but it's in effect until somebody repeals it, which I hope they never do. And what that means is, and most of these non-subscriber policies have implemented this, that they include a mediation arbitration agreement. So the employee, even though he has the right to sue for benefits, it won't be in a court of law, and it won't be in front of a jury. It will be determined by an arbitrator. Now, don't think for a minute that that really puts the benefit on the side of the employer. Here's where some employers don't like it. The arbitrator is allowed to award any and all damages allowable under the law, the same as a judge. The problem for some employers is that binding arbitration means binding arbitration. It is non-appealable. Once he decides what the damages are, if any, then it's over. Now, the good thing, mediation arbitration runs 3 to 6 months versus 3 to 5 years for a lawsuit, so it can be a good thing. Now, some other funny things about binding arbitration and mediation in the non-subscription world. Most all of these plans come with that. There are a couple that don't. And the funny thing is, there is mediation binding arbitration in these other plans between the insurance carrier and the employer, meaning the policy. But the ERISA does not have an endorsement or an attachment or some other word for that to put them together for mediation binding arbitration, because that carrier has decided that they feel that they're better qualified to settle a case rather than let it go to an arbitrator. So you need to know that when you're looking at all these different policies and these different quotes that you can get for non-subscription, you need to know which ones have mediation binding arbitration and which ones do not, because that would be something important for your employer. Now, there is actually one out there that leaves it as an option. And unless it's explained really well to the employer, I'm not sure that he'd be able to make a qualified decision about it, but you need to know that as well. A neat thing about mediation binding arbitration, everybody says, well, that's fine as long as the employee agrees to it. Well, if you go back and read the Federal Arbitration Act of 1934, and I don't recommend it unless you really, really want to go to sleep, There is no requirement for the employee to accept, to agree. There's no requirement for a signature, period. All the employer has to be able to do is prove to the court that he informed his employees that from this point forward that we would settle our disputes by mediation, binding arbitration. Now, what better way to do that than with a signature? So you're going to find that most all the carriers require that you hold a meeting and you have everybody sign the sign-in sheet and you pass out the mediation arbitration agreement, you have everybody sign it, and well, what if a guy doesn't want to sign? I get that question all the time. Fine, just have the supervisor put his name on the top of the form and then put a sentence on the bottom saying employee refused to sign it and date it, and have another witness do the same thing. And if that employee stays long enough to receive his next paycheck, he has no recourse. He is covered under the mediation binding arbitration. Now, this is really one of my favorite topics, and I could sit here for probably all day and talk about mediation arbitration, but in a short explanation to an employer, that's really all you need to know. So if you have any additional questions, don't hesitate to call me. Remember, we work for Texas Non-Subscriber, and the number here is 972-675-6596. Call me anytime.